Friends, on 22nd of this month, 22nd of August 2018, the Supreme Court of India delivered a beautiful judgment in Civil Appeal number 8621 by 2018 regarding a fundamental right. Here it is between State of Uttar Pradesh and Dr. Achal Singh. Right. So the Supreme Court of India opined that, of course, a right to retirement is a fundamental right, but it will not surpass the right to life as envisaged in the Article 21 of the Constitution of India. Right. When we go to the details of the case, Dr. Achal Singh, who was working as a joint director in the Medical and Health Department of Uttar Pradesh, he applied for voluntary retirement and has given a 3 months notice in advance also. Right. According to the fundamental rule number 56 of the Uttar Pradesh, so giving notice, advance notice or 3 months notice is sufficient to get the retirement. But the government of Uttar Pradesh did not agree for the same. Right. So the government of Uttar Pradesh, since it did not agree, Dr. Achal Singh has approached the High Court of Uttar Pradesh. The High Court of Uttar Pradesh, basing on the judgment of Mr. Dinesh Chandra Sangma versus State of Assam. So it stated that when once the notice is given and when the 3 months time is passed, it is deemed that he retired voluntarily. It is deemed that he voluntarily retired. Of course, the Supreme Court of India was approached in this matter by the government of Uttar Pradesh, because in the view of Uttar Pradesh, there is scarcity and paucity for the surgeons, for the doctors who have to work in the provincial areas. Naturally, you may be knowing the doctors, once he takes the degree, he wants to work in the urban areas only, even though there is a direction that the doctors should work in rural areas. I think most of them are not following. Right? So normally there is a necessity of hospitalization or the treatment for the poorest of the poor. Definitely the poorest of the poor or the poor people, they will come to the government hospital for treatment, whether you agree or not. Of course, the people who have got money, they will go to the corporate hospitals. The middle class people, they may go to their choice hospital. But it is for the poor people definitely to come to the government hospitals. And if the doctors are allowed to take voluntary retirement like this, then there will be a dearth of doctors. You may be knowing, when a doctor is transferred to a rural area, definitely he will apply for resignation, voluntary retirement. He will go away. Right. The argument on behalf of Dr. Achal Singh is that, according to rule number 56, he says that so mere giving notice is sufficient. Why? Because only the permission of the government of Uttar Pradesh is necessary only in cases of pending disciplinary action. Normally the government has to give him gratitude, so many benefits, other things. For that matter, they have got the right whether to decline or deny or approve the so-called voluntary retirement. Now the Supreme Court of India has taken into view of the 3 rights in the Constitution. Number 1, fundamental right. According to Article number 19(1), subclause 1, subclause G, everybody has got a right to practice his own profession. It is his will and good. Right. At the same time, directive principles of the state policy. Article 47 says that the state should see that the nutritious levels of nutrition and health care, they should rise up. So it is the duty of the government to see that the people or the children, the people nourish well, and the public health should be given utmost important. Right. As far as the fundamental duties are concerned, Article 51A says that everybody should have compassion for human being. No doubt, doctor being a professional, since he has got a lucrative private profession, he cannot go away like that. He has to wait till the government finds some substitute for him. Of course, he can voluntarily leave the place, it is his right. But when the others are available, that when substitute is available, when substitute is not available, the government has got a right to deny his petition for voluntary retirement. Right, we have seen so many people. A doctor, he applies leave and goes away. He goes to Dubai or Iran. He will not be found. Whenever his evidence is necessary in the court of law, it is highly difficult to secure his address. There are cases like that. We are bringing other doctors and say that I have seen his signature and identify the signature, like that we are doing. But that problems are there. The doctors voluntarily they apply for resignation. They apply for retirement resignation to go away. But what happens if the strength already the strength of doctors is very less, so the strength of surgeons is also comparatively less, the strength of efficient people is also becoming day by day lesser. Therefore, there is ever necessary for the government, for the doctors to work in rural areas. If they do not want to work in areas and they want to go for private profession, okay, they should not have joined the department. Having joined the department, having come to the level of joint director, Mr. Ashal Singh is not expected to take voluntary retirement as per this. This is the ultimate decision given by the Supreme Court of India. Actually, Supreme Court of India framed these three concepts. Now, it is a typical case where the fundamental rights are discussed. Then the directive principles of state policy are discussed, Article 47, and the fundamental duties, Article 51A. Previously there were 10 duties, now it has become 11 duties, all the duties. So friends, please go through the Constitution of India, particularly fundamental rights, DPSP, and the fundamental duties of the citizen, and definitely you will appreciate the judgment given by the Supreme Court of India. Thank you.